Thank you, Minister. I think this is a timely bill, and I'm pleased to have an opportunity to move amendments 4 and 5 taken together, because obviously they are linked. Minister, I hope that you will agree that that these amendments present an excellent opportunity to inject two badly required elements into the appointment of members of the judiciary, which sadly has become, or perhaps always was, an inherently political process. And I think these two amendments provide an excellent opportunity to take the political or politicisation out of the appointment of members of the judiciary, and to inject two important elements to that process. One is the appointment of members of the judiciary on the basis of merit, and secondly, to inject a much greater degree of transparency into the process, which I believe is very much needed and overdue. I was pleased, Cathaoirleach, recently to have an opportunity to support a bill sponsored by Deputy Shane Ross, which strove to achieve the same ends. His was an amendment, a proposed amendment to the Constitution, but I believe that this is a very obvious and logical way to achieve essentially the same outcome. Perhaps to lend weight to the argument and to illustrate that this isn't simply something that is being sought from members of the opposition, or perhaps some more silent members on the government benches. It's also something that the judiciary itself is seeking. The current Chief Justice, Susan Denham, whom I think everybody in this House would hold in extremely high regard, has explicitly warned about how politicised the appointment process of the judiciary continues to be. And the Minister, I'm sure, will be well aware that in a report published by the Judicial Appointments Review Committee in January of this year, which essentially my amendment addresses, the Chief Justice herself stated, "It is increasingly clear that the relative success of the administration of justice in Ireland has been achieved in spite of, rather than because of, the appointment system." That's from the most senior member of the judiciary in the land. The report itself went on to further state, "The key to reforming the judicial appointment system rests on reform and development of the Judicial Appointments Advisory Board. The number of candidates for a single judicial post submitted by the Judicial Appointments Board for governmental decision should be reduced to 3. Where there are multiple vacancies in a court, the number of vacancies should be increased by no more than the number of additional vacancies." That is precisely what my amendment would achieve, Amendment 4. If it's accepted by the Minister, it would without any delay ensure that instead of the ludicrous situation where 9 nominees are suggested to government, the government would only have a choice of 3 to select from. The establishment of the Court of Civil Appeal is obviously long overdue, and we should, I think, use this opportunity to provide genuine reform in how the new judges of this court will be appointed, and further vacancies for other courts. I think it's fair to say that the Irish legal system and judicial system is not comparable to many other jurisdictions around Europe and indeed around the world, but I suppose relatively similar common law systems in Northern Ireland, Scotland, England, Wales and Australia do exist, and there are judicial appointments commissions in all of those jurisdictions. There are now judicial appointments commissions in the United Kingdom jurisdictions of Northern Ireland, Scotland, England and Wales, while the Commonwealth Attorney General of Australia is statutorily obliged to consult widely with his state counterparts and legal colleagues. So I think that my amendment, which would essentially echo what emerged from the report in January of the Judicial Appointments Review Committee, would be a really important and a really constructive and reforming stepping stone to a much and radically reformed appointments process, which I believe is urgently needed, which clearly members of the judiciary also believe, including the most senior judge in the land, believe is urgently required. I think that we would end up with a system which is based firstly on appointment on the basis of merit, and secondly with, as I said at the outset, a much more transparent system, because according to my amendment, it would be required that an explanation of the nominees, the three nominees, would be provided to government for government's consideration. But further to that, in my second amendment, the government would be obliged within 14 days in advance of making their appointment to disclose a report indicating the reason that it has recommended a certain person for appointment to the bench, or indeed promotion from one court to the other. So all of this is logical. All of this tallies with the government's commitment, the government party's commitment before the last election, to introduce much more transparency, to end cronyism, to take the politicking out of these sort of appointments. It was a clear commitment in relation to state boards and so on, and it makes sense that we completely depoliticise the judiciary. I do believe that we have an excellent judiciary in this state who by and large have served the state with some distinction, but it is important that the process of appointment is beyond reproach, that it is entirely independent, that it does not come under any form of political intervention, pressure or interference, and I believe that this is the way to achieve it, and I think it's very clear that the Chief Justice also shares that view, as does the independent review body, which made its recommendations in January. So, Minister, I hope, being new to the brief and with the zeal of a newly aligned cabinet, a regenerated junior ministerial bench as of today, that you will seize the opportunity to introduce a radical yet long overdue reform, and I look forward to your response, and I hope, Minister, that you will accept these two amendments. Thank you.
Thank you very much. Thank you, Deputy. Well, certainly we had a commitment in our programme for government, which we certainly intend to keep in relation to the reform of judicial appointments. And I have to say that I believe we have been, in this country, we've had excellent judges, as you said, Deputy Creighton. And I think, obviously, given the critical importance of the role of our courts and our judiciary, we have been very fortunate in this country when you see the experience of other countries in relation to judicial appointments. Both of these amendments are directed towards modifying the current regime, as you say, which applies in relation to the appointment of judges. The first amendment seeks to adjust the arrangements whereby the Judicial Appointments Advisory Board gives effect to its functions as a recommending body in respect of judicial vacancies, by providing for the recommendation to the Minister of 3 names in respect of each vacancy. It may be helpful if I briefly outline to the House the provisions which apply at present in relation to these matters. I am conscious we recently discussed the same amendments, Deputy McLaughlin, when you introduced some legislation to the House. Under the Constitution, judges are appointed by the President on the advice of the Government. The current process for the appointment of judges in Ireland is set out in sections 12 to 17 of the Courts and Courts Officers Act of '95, which established the Judicial Appointments Advisory Board. Upon request by the Minister, the Board advertises and considers applications from persons interested in judicial office. The Board is then required, under Section 16, to forward the names of all applicants and recommend a minimum of 7 candidates. Where there are less than 7 applicants, and where the Board is unable to recommend to the Minister at least 7 persons, then it must submit to the Minister the name of each person nominated and recommend to the Minister for appointment to that office such as those persons as it considers suitable for appointment. So the role of the Judicial Appointments Advisory Board is extremely important, and has people of the very highest calibre, I should say, serving on it. Section 16(5) provides that where more than one judicial office in the same court stands vacant, or in advance of more than one vacancy arising in the same court, at the request of the Minister, the Board shall submit to the name of each person who has informed it of their wish to be considered for appointment, and shall recommend to the Minister the names of at least 7 persons, as I said, that are suitable for the vacancy. And then such lesser number of names as the Minister shall specify following consultation with the Board. And it is this particular provision which your amendment seeks to amend. You're suggesting a new subsection 5 in section 16 of the Courts and Courts Officers Act. This would have the effect of allowing the advisory board to recommend 3 names for appointment for each vacancy where there is more than 1 vacancies. However, this would leave intact the existing provision whereby at least 7 names would be furnished in respect of a single vacancy under section 16(2). And you would have, I think, the fairly extraordinary anomaly, and I don't think you would have meant this, whereby 7 names could be recommended for 1 judicial vacancy and only 6 names would be recommended for 2 vacancies. The Deputy's second amendment seeks to introduce a new provision whereby the Government shall, no later than 14 days in advance of the appointment of a judge, disclose a report indicating why the Government has recommended a person for appointment or promotion. Now, currently the Government must, under section 16(6), in advising the President in relation to the appointment of a person to a judicial office, first consider for appointment those names those persons whose names have been recommended to the Minister, as I've said, by the Judicial Appointments Advisory Board. Section 16(8) then goes on to recommend that the names have to be published in Irish Ifigul, and the notice shall, if it be the case, include a statement that the name of the person was recommended by the board to the Minister pursuant to this section. And certainly this Government has never gone outside the names which have been recommended by the Judicial Appointments Advisory Group. I would observe that ultimately a desire for a more transparent and accountable procedures must be balanced against the requirements of confidentiality that are relevant to any appointment. And it is in this context that publication of reasons for appointing a person to judicial office needs careful consideration. I'm sure you'd agree with me that if you're going to give public reasons about why a person has been appointed or not appointed, as the case may be, by implication, one would need to consider very carefully about the objective of that and how it would be done and precisely what the objective of it was in terms of the level of detail and the objective of publishing such information in advance of an appointment. And I think you are saying 14 days before the appointment. So I'm not quite clear what you had intended in the amendment in relation to that period. The Deputy will be aware that I am and the Government are overseeing a consultation process on the system of judicial appointments with the intention of instituting reforms to enhance the current system. The Department received a significant amount of material earlier this year as part of the process, with views ranging across a very significant number of areas. For example, different aspects of the eligibility provisions, the exact role of JAB, and a variety of other arrangements, the arrangements for a variety of other issues, I should say, including the arrangements for appointing judges. So we've had quite a number of submissions for that review, which former Minister Alan Chatter initiated, I think, in December of last year, and there was a time limit on the consultation period, obviously. So we will shortly have a report on the outcomes of the consultation, signalling key emerging issues and options for legislative reform at an advanced stage of preparation in the Department. It is inevitable that this report, when I publish it, will become the focus of a further consultative period with all relevant stakeholders. And it is anticipated that this process will take place in the second half of this year. And I do want to thank all of the people who made submissions to this process. And we will have an outline of legislative proposals in this area towards the end of the year, 2014, this year. In view of the ongoing consultation process that we're involved in, the submissions that have been received from a variety of stakeholders in terms of the very issue in which you are submitting your amendments tonight, I hope that you understand that I don't want to preempt the outcome of the process, which is well underway, and for that reason I'm not in a position to accept the amendments tonight. Deputy Creighton.
Cathaoirleach, thanks to the Minister, and I'm aware that the consultation process is ongoing. It's obviously wider and broader than the subject matter of these amendments, and I have to say I don't see the process as being necessarily a justification for not considering the application and the implementation of the proposal that I have outlined. I think it's very simple. and it's very much in line with the very clear recommendation which came from the Judicial Appointments Review Committee in January. I'd be very surprised if a further consultation process would throw up anything that would be in any way anathema to that, or would somehow deviate from the spirit of what I'm proposing. I accept the perhaps unintentional anomaly. I'm sure it's something that by ministerial amendment could be very easily rectified if the Minister were so inclined. I think I'm not for 1 second firstly suggesting that the government has gone outside of the parameters of what is set down by legislation. I think the government has adhered to the letter of the law. I suppose what I'm talking about is changing the letter and the spirit of the law, and that's what my 2 amendments are essentially aspiring to do. And I think that it would be very much in line with commitments of the programme for government and the pre-election promises of both of the government parties. Were you inclined to do that? The idea of limiting the scope and choice in terms of numbers that go before government would obviously ensure that there would be far less scope for ensuring political appointment, which we all know, of course, does occur, and would in fact restrict and limit, and I think ultimately would ensure a lot more trust in the process for the public at large, who I think at this stage are very well aware of how politicised the process of appointment is. I don't think, Minister, from your remarks that you disagree with that in any sense. The Judicial Appointments Advisory Board, I think, is simply at this stage it has outlived its useful purpose. It's out of date. It's not in line with international best practice, and it's the procedures that are set out in legislation do allow for manipulation of the process, and certainly do lead and have led repeatedly to political appointments. And I mean, I hold my hand up as a member of the Law Library, as a barrister, not practising obviously. I'm very well aware, and all of my colleagues are, of just how politicised this process is. So, you know, Minister, I fear after 3 years, more than 3 years now, in the lifetime of this government, it is extraordinary that that process was only launched before Christmas of last year. It is disappointing. It's something that I think your predecessor should have prioritised, because it's actually a simple reform. It's something that could have been done very, very quickly. You know, it's popular in Europe these days to talk about reforms within 100 days. I mean, it's certainly a reform that should have and could have happened within the first 100 days of the lifetime of this government. That didn't occur, but I really do hope that you will now accelerate the process. I worry that a further process of consultation is going to bring us to the end of this year. Who knows what lies ahead in 2015? There could very well be an election before the summer next year, and it would be a real shame that a government that promised and, you know, was elected on a wave of popular support for radical reform, radical change, the ending of cronyism, of sort of, you know, all of the sort of the problems, political problems that blighted previous governments and blighted this country, and created such a toxic culture in this country that that an opportunity to make such a simple reform but such an important one would be missed by this government. I think it would certainly be a major disappointment, not just to those of us who care about transparency in public life, but also, I think, to the wider public who expected and had high hopes for this government. I mean, you asked for clarification on the issue of publishing, or an obligation on the government to publish its reasons. I don't think it's anything that we should be concerned about. I don't think that it would give rise to any sort of confidentiality concerns. It simply would oblige the government to put forward logical and reasoned explanations as to the qualifications and the suitability of members of either legal profession in respect of their appointment to the bench. And I think that that is perfectly logical and something that we in fact should should expect and demand in a free and open democracy such as ours, not something that should be feared. We should be moving well beyond the days of appointments behind closed doors and, you know, nods and winks and so on. It should be very, very clear and transparent, and I think that the logic behind it is simple. There's no mystery to it, and there's certainly no fear or threat in terms of confidentiality. It's just simply that if a person is good enough to be appointed to the bench, that the government would have to demonstrate in appointing them that they have the requisite talent, experience and qualifications, and I certainly don't see any reason or logic for concern about that. Thank you.
Deputy.